It's Lisa from Been There, Got Out. Tonight's guest is Jude Egan from California. He's a divorce attorney, family lawyer. He's done other kinds of law, but that's the main kind of law he's done. So this is going to be his first for real Instagram Live. Let me make sure he didn't just join. I got to let him in if he did. Nope, he's not here yet. So hopefully he will be here any second. And we love to tell you guys that our content is driven by our clients, and we should tell you, there he is. So Jude, let me get you on in a second. But we should tell you that Jude came recommended from one of personal clients. And so he's one of the lawyers that gets it. You heard what I just said?
All I heard was gets it.
Yeah, no, I said, you're one of the lawyers that gets it. So everybody's always asking us, like, I got to find an attorney that understands, and they need to understand personality, blah, blah, blah. I'm like, well, they're hard to find, but based on the recommendation we got for you, we definitely think you get it and then some. So Jude, why don't you start by just telling us a little bit about your background? And again, thanks for coming on.
Oh, you're welcome. Thanks for having me. I guess I'm coming up on 17 years in practice as a lawyer. The last 15 have been mostly family law. I had a little divergence in my academic career and got a PhD along the way, and that was in writing about nuclear weapons safety, and so it didn't really lead in. I guess talking about nuclear war it probably is useful to a discussion of high conflict divorce, but
right. Congratulations.
To do with that, but I've been mostly practicing family law. I'm a certified family law specialist, certified by the State Bar of California, and I've been trying to do, the academic in me wants to do more, has been doing more writing. So during the pandemic, I was publishing a lot about divorce issues and pandemic divorce issues and things like that. And I do a lot of appellate work too. So I think some of the things we're going to talk about today are some appellate decisions that we didn't get the outcome we were looking for, but I think we changed the law in a positive way.
Yeah, so that's really significant. Okay, so one of the things that you do, I know, is you're sometimes a minors counsel.
Yes.
Could you explain what that is? Because I know when we first heard, in different parts of the country, in different parts of the world, we say guardian ad litem, minors counsel, attorney for the child, and we thought, oh, it's probably about the same thing, but it's not, right? Can you tell us what the difference is?
Well, so California has a law that says, it's called Family Code 3150, and that law describes what minors counsel should do. So minors counsel are lawyers who get appointed to represent kids. We get paid, but we get paid by the state or the county, and it's far less than our normal hourly billing rate. And our job, at least under California law, in theory, is to just be a lawyer for the kids. In other words, we're not witnesses. We're not supposed to make reports. We're allowed all the same access to information that parents are allowed access to, and not really any more than that. We're really just lawyers in a case, a third lawyer who's supposed to put on a trial. And that was the rule until the case, which was Ramsden versus Peterson, which is a case that I argued unsuccessfully to the appellate court, that said that our minors counsel was making recommendations in a case. I was not. I was a lawyer for one of the parents, and we tried to stop her from making recommendations under the theory that she's not an expert, that she's not trained to make recommendations, that what she's really good at doing is being a lawyer. And if she's listening in, I want to say she's a very good lawyer. But I didn't think at the time that she was an expert who could be a witness in a case. And it says you're not supposed to be a witness. The appellate court affirmed the trial court's ruling, basically saying that lawyers for children could make recommendations. And that has kind of created a blurry line between what I think of as a traditional guardian ad litem, who is a witness. That guardian ad litem goes out and writes a report and comes back and tells the court, this is what we should do under the circumstances, whereas a lawyer is just supposed to argue. And we don't have to find information, we just get to present it. And I think now there's a blurry line in California, and it's kind of gummed up the works a little bit. I have a lot of lawyers who are pretty upset about this decision.
Yeah, so if you're an attorney, I'm thinking in my head, it sounds like minors counsel is what in New York is called an attorney for the child. which again is appointed by the court. It's neutral in terms of like, it's not like one parent is paying the salary and could influence it.
Right.
So, but so you're in a little bit of a bind though, as when a minors counsel does this kind of work, right? Because talk about best interests.
Yeah. So one of the issues that as a lawyer, it's typically really easy. When I say easy to do my job, and what I mean by that is it's easy to work with my client, find out what they want to have happen and advocate for that. That doesn't mean I won't advocate with my client to say, hey, I think your position is too strong. I think that, this isn't something I think we should ask for, and here's why. I might have a back and forth with my client, but once we've understood what the advocacy position is, then we're like and I'm sure your listeners all know, we're like a wind-up doll, right? We just point us in a straight line and we just keep going, right? That's advocacy. But as a lawyer for kids, you kind of have
Oh, Jude, I think we lost your volume for a second. Can you hear me?
my phone was ringing.
It always happens. Okay, say it again. So as a lawyer for the child,
you sort of
go ahead.
Two hats, because you have a client and the client has an interest, and that interest might be I want to live 50-50 with both parents, and that's what they tell you, right? And so we're trained as advocates to want to do the thing that our client wants us to do, but the law also asks us to look at the best interest of the children, and this is what I don't know if you say guardians ad litem. I think that's the way you say it, instead of guardian ad litems. But guardians ad litem do that. They're supposed to figure out what the best interests are of their ward, and then they write reports, they advocate for that. That's all they do. But they're determining the best interest. They may have discussed it with their client, but in the end of the day, they're going to make the decision. That isn't really what we're asked to do, or what is partially what we're asked to do, but we're also balancing that against pure advocacy, which is, what does our client want? And so, if you're interviewing a stressed out 11-year-old who's got one parent lives in Los Angeles and one lives in Paso Robles 4 hours away, and they're trying to go every other weekend back and forth and spending 8 hours in the car, but they tell you, I want to see both parents a lot, but I'm also really stressed out about being in the car. It puts a bind on the person who's representing the child, because on the one hand, they're not really old enough to speak for themselves. At 11, the law recognizes 14 in California, but maybe 12, but probably not 11. So on the one hand, you want to advocate for what they want, which is time with both parents. On the other hand, you're balancing that against twice a month doing an 8-hour drive with a stressed out parent, which makes the drive even more stressed out. And how do we do that? So I think that it's a little bit challenging. I did look up, under Florida law, they call it attorney ad litem versus guardian ad litem. And so it might be that they're kind of blurring the line for us, I guess, but saying we should both act as a guardian ad litem and act as an attorney for the child. And I think that creates a conflict.
Yeah, I was going to say, how can you possibly argue? How can you argue for a client when you're torn, because it's a child and you have to make a decision? And if you're not talking directly to the parents and gathering information, how do you know which parent gets more time?
So what in my office we've tried to do, and I have my law partner's name is Helen Zajic, and she's a fabulous minors counsel and a great lawyer. But we've talked a lot about this, and especially as the appeal was coming up, and I was submitting writing briefs, and she was reading them, and we were going back and forth. And ultimately, when we argued it, we took the position, and we still do, that we're not experts, and that we don't want to make recommendations, even though our judges want us to make recommendations too. In fact, that's probably the biggest strain, is the judges want us to do it because it makes their lives easier, right? I mean, they figure we have somebody who's very knowledgeable, has been doing this a long time, and I trust their judgment. So if they're going to come to me and say, this is my recommendation, I mean, I don't know how many people have worked with minors counsel in the past, but it seems to me whatever minors counsel wants, they get. And so that's a whole lot of power to have without a social work degree, without a licensed custody evaluator, degree or PhD in psychology or whatever. We're really putting a lot of pressure on lawyers to make those decisions. So we've started to say we're not going to make those decisions. Our Arizona admissions insurance doesn't cover that. You know, we're here to be lawyers in the case, and we'll advocate for the position that we think is best, and we'll ask hard questions and push the judge to make a decision.
Yeah, that is a really hard position to be in.
Yeah.
And I'm sure someone's always mad at you, just
Oh.
like they are with guardian ad litems or guardians ad litem. And also with that kind of situation, how often do you see, or how often do you feel like a parent is manipulating a child to say something? Like, can you tell immediately, or do you have to have several meetings? Because we've talked about this with other attorneys, and they say it usually takes a few times for something to come out.
Yeah, I try to ask questions, especially of little kids. You know, I try to ask questions that will encourage them to tell me things that they don't think are. If a kid's being manipulated by a parent, and they then are guarded with me, right? Because they're afraid to tell me because dad is pushing them to, or mom is pushing them to say a certain thing. They don't want to tell me. So I try to ask them other kinds of questions. You know, what do you do at dad's house? And what time do you normally go to bed? Oh, do you guys play, what video games do you guys play? Whatever, to try to get to them to start talking about, for example, co-sleeping, right? We have kids who are co-sleeping with a parent and they're 10 or 11 years old. And there's just, that may not be direct manipulation, but it's certainly a subtle one, because you have a kid who one parent's house, they have to sleep alone. At the other parent's house, they get to, you know, cuddle with mom or dad. And so but they know they're not supposed to tell me that. So we have to sort of get, you know, so we sort of talk around it until I see if I can pull out of them, you know, some information that would be helpful about that. Normally I don't worry about it unless there's a really strong feeling. Like when a kid says I want to live with both parents, I'm not looking for manipulation at that point. I'm
Right.
trying to make sure they're okay and that they're happy and healthy in both households.
Right. And then they're neutral. I'm talking about the one where it's like, no, I only want to be with this one parent.
Right.
And I don't want to talk to the other one.
Right. When that happens, then you're really looking to find out, is this a thing that the parent who they don't want to be done something that has caused that, or is it a thing where the other parent has sort of pushed them that direction? And the only way to get that out of them is to just talk. And so that does sometimes take 2 or 3 meetings, or sometimes I'll you know, have a face-to-face meeting when we first meet. And I'm a really big man, so when I have little kids in, and I have to really almost sit on the floor with them. So I like, or like we're doing now, because the size difference isn't so obvious to them, and they don't, you know, recoil. So we definitely, I will spend a few sessions like that, or we'll check in and say, okay, let's check in, you know, can we just talk for 5 minutes? What's happening? And how's baseball all-stars going, or whatever. And then, you know, we just keep in touch that way. They also tend to know when trials are coming up. And that's another way that I know that they're being told things, because they'll say, well, you know, mom says we have court, you know, coming in, you know, and we might talk a little bit about that. And I'm trying to learn in that case, how much is, if they know about court, they only could have known it but from one source, because they're only seeing one parent. What do you know? I mean, what are you hearing? You know, what's, you know, and try to get that kind of stuff out of them. That comes best from us talking on a regular basis.
Yeah, as you're saying that, I'm thinking that's, to me, with our clients, is often a red flag, because a lot of the agreements and things written here are always like the kids should really stay out of legal proceedings and shouldn't know unless they're directly involved, but they should be kept ignorant of that as much as possible. Is it similar where you are?
Yeah, we want them to be, but I try to balance it. I think the older kids, it's impossible to, it might be more stressful for the older kids to not know anything. And yeah. I got a case a few years ago where the husband tried to kill the wife, and the kids, they were trying to shield it, the kid from knowing, but Instagram was killing them, because the kid knew. I mean, everybody was talking about it, and to not talk to the child about it at all, to try to pretend like this wasn't going on, was causing even more stress. Now that's way outside the norm, but
right.
They know things are coming up. So I think there's I don't know what it is, but exactly, but I think there's a healthy way to talk about what's going on. And with my own daughter, you know, we just, when she would ask, we would say, look, mom and I are going to make the decision. together, or we're going to, we didn't have to ask a judge, but we're going to make that decision so you don't have to. There's probably a way to do that that can be healthy. But when kids are really, involved and they're writing declarations, when the 18-year-old writes a declaration into the case and they're saying, dad's a bad parent or whatever, then I'm really starting to wonder, right? Now, why is this one writing that too? If everybody's writing these things, all the kids are involved, the older ones, what's happening with the younger ones?
Yeah. Interesting. And again, like very, very tricky, I bet. All right. So the other day when we were talking, you had made a comment, and I knew you wanted to think about this, about taking lawyers whose cases you hate. And so I thought my question is, what kind of case do you hate to take?
Well, so I actually, thinking about it later, I think what I meant to say is that we were talking in the context of cost, because there's no question that we're expensive, right? I think that one thing about the area so I practice in the sort of the central coast of California is the area between, say, Santa Barbara and San Jose, and so it's a big, long area. There are, the Santa Maria is a city with 120,000 people. It's the biggest city actually between Ventura and San Jose, but it's a pretty poor city. So we've really learned to do a lot with a little here. Whereas when lawyers in other bigger cities get cases, they're going to figure out how to bill $100,000, and every case has to be that. That's their practice model. And we don't have that. We don't have that option here. So we've really learned to, cut to the chase as quickly as we can on what we're trying to accomplish, and say, let's spend our money on the thing you're trying to accomplish the most. And then after that, we can sort of figure other things out. I think my comment was, there are some lawyers that I don't like working with, and I tend to think that I get along with most people. I get along with most lawyers even, and I have ways of working with people that are even sort of insufferable. But there are some lawyers that I cannot work with. I can't do it. And it's not worth it to me, even if someone said, look, it's a blank checkbook, you could just, as many hours as you want to spend on it. It isn't worth it, because I never get those minutes of my life back that are, my life is being stolen by them or something like that. And they probably hate it with me too. It's not like I'm an angel. It's just that. So I think that's what that comment was, less about cases that I hate and more about lawyers that I hate, I guess. I wouldn't have said that.
I wasn't sure because I think I remember talking about maybe my own divorce attorney who was similar to you. He got along with almost everybody except two people. And my ex fired his first attorney during our divorce and hired one of the ones. And I remember distinctly, Chris and I were going to a funeral, and my lawyer called and was in an absolute panic and said, your chance of going to trial just increased by 80% because one of the two people that I can't stand just took on the case, and she's going to run up the bills. And she did. And it was such a nightmare. It was such a nightmare. It was like, we have to get away from this person, and we couldn't.
Well, sometimes, the beauty of having a law partner who is every bit as good a lawyer as me, and in many ways better, is, and we get along with different types of people. So we even just today, we traded cases, partly because of, I'm not going to say why, but we traded cases in part because of who was on the side, realizing that she would have a better chance of working with the lawyer who had just come onto a case than I was going to have. And if she had said to me, I can't work with her either, I probably would have called the client and said, I think you should find somebody who can work with her, because we're very busy. We don't need to churn cases to try to make our money. I'm happy to send clients to the right fit. And people send clients to us for the right fit. So that's okay with me. But of course, as you know, we sort of form a bond with our client. I mean, I think divorce other than any other kind of law, we really form a bond with our clients. And so it's hard to let them, if you like your lawyer, it's hard to let them go. But if they'd be doing you a service by saying, look, I can't work with this lawyer, but who I think can, is this other person, and have you go there and keep your costs down by half, because otherwise it just turns into just like a back and forth and back and forth. You start seeing lawyers sending nasty note, just watching it ratchet up. Every one of those is a 0.4, you know, and every one of those costs you $160. And they're just back and forthing at each other and accomplishing nothing. And so so part of the reason I think we were going to talk about it is we were talking about in terms of fees. If you see that happening, that's when you want to say, like, it actually happened in my office. We had a client who was not a family law case, it was a different lawyer. I'm not Helen, not me. But the client said, all I want you to do is just give her the stuff. I don't fight with her. I don't care what she has to say. Just give her the stuff. And I think that's right. I think that the more we can do that, the more that we're saving you money. We're also saving our own life force, because we get stressed out and have to go take a walk and you know, ponder our life choices just like you guys do and do, and so we have to do all that too. So it's better for everybody, including your cost, if you don't need your lawyer to sort of, you know, punch them in the nose because they punched you in the nose. Like, I can't tell you how many times I get a letter and I show it to the client and they say, you're going to take them out now, right? And I'm like, yeah, I can, but I just want you to know I'm going to write this letter back, and then I'm going to get a letter back, and it's going to be even uglier. And then you're going to want me to punch them in the nose again. And now how many letters have we exchanged? And it's just cost you $1,000 and we're nowhere. And so I can usually talk them back into, let me write something short and newsy and get it done and, you know, move it out.
Yep. As you're talking, I don't know how often you saw me keep nodding my head, because my own lawyer who helped me with part of the case got into I call it a pissing contest with the other lawyer. And we were on vacation and I kept getting copies of these letters that were saying nothing. And I'm like, stop it. And got nowhere. And $18,000 later, just crazy. All right. So Jude, you're spinning on my screen. I hope there's nothing wrong with the connection. I'm not sure if you can hear me, but can you still hear me? Uh-oh.
Yeah, I can.
Okay. All right, good. Yeah, it just started spinning. All right. So we also talked about how or why it's so important to get a trial date. Can you talk about that?
Yes. I love trial dates. I love trial dates. I don't love trials. I mean, I actually love trials. I love putting on trials, but I don't love it for my clients. I love it for me because I like doing it. But I love trial dates because they are a burning fire at the end of the road. Like so my case just recently, we got a trial date for February 2023. Well, that feels like forever away. But what I say is, you know, that's the day. You're done on that day, barring something totally unforeseen. We have an 85-year-old judge. I mean, it's something could, God forbid, but you know, things can happen, right? That could cause that date to go away. But one thing I love about this judge is he set the trial date. He said, I'm not making any rulings till then. Just get ready for trial, you know? And so then as the trial date comes up, of course, everybody knows that you're starting to get more stressed, but that also starts to put pressure on settlements, right? And when it's 7 months away, you don't feel like we have a problem, but yet we're not worried about it yet. But as it starts to get closer, there starts to be a little bit of, you know, I'll call it stress. I was going to say panic, but maybe there is panic too for the client, but there's certainly more stress on everybody to get it done. And I have a book that I've been working on for several years that's tentatively titled The $35 Divorce. And it's because the book was going to be $35 and that it was going to tell you everything you needed to know from not a no-low press kind of book, but like how to think about it. But one of the things I say is the most important thing that you can do in your divorce is get done with it and not keep doing it. So when you have a date and you know that date is your date, you know it's coming. And I think the killer with the pandemic was, especially when the courts first closed down in California, was all of our trial dates went away and people just sort of sat, you know, like metaphors like being in a sailboat with no wind. You're just sort of sitting there, and it was insane. So to get back to a time when now we're having trials and their dates are set, you know it's going to be over then. Even if that date is still 7 months from now, you know it's coming. And I think my math was bad. It was 8 months from now, whatever for that case. Yeah. But it's coming anyway. And so it has a psychological benefit of knowing this is going to be the day. It also has the benefit of pushing people toward reasonable positions for settlement. And you know, one of the things I talk a lot about in the book is that we have that there's a band of reasonable outcomes. There's always, you know, between 35 and 65%. And if your spouse makes an offer within that band, you should consider it. And I don't go as far as to say you should take it, but I think what happens is people take way outside unreasonable positions. And then as they start to come in toward the center, which is what happens as you get toward trial, then you have to start thinking, I'm within that 35 to 65 or 40 to 60 range now. This is on the money, on the kids, on every issue. I'm within that range now. Yes, it's 59%, and I would rather have it be 41% on the other side. But it's reasonable. It's a reasonable position. Should we take it? What's the cost of not taking it? Well, it's $40,000 in attorney's fees and 3 days of trial, and you still might lose. Like, that's one cost. I mean, that's a massive cost.
And your energy, like you said, your life force, and the time that it's taking you away from other things.
Right, exactly. And so my view is anytime you get within the range of reasonable outcomes, and one of the things I do in there is teach you how to find what the range is, what the worst case scenario, best case scenario is within that range. Once you've identified that, then anytime you're within that range, you should be thinking about, can I make this work? You know, my spouse wants $100,000. Where am I going to find it, right? Can I find it? Could I leverage it? If I could, what would it look like? You know, who could, no, I can only come up with 60,000. Well, you can tell them I can get 60. Can we be done? You know, can I pay you 40 over time? You know, because getting done is just, it has to be the most important thing, because it's all your peace and sanity back. And we're talking about parenting. All of that energy that you were spending on your divorce is now you can spend on your kids, you know, and on yourself and your new partner and all of that stuff. And so I think there's a ton of benefits to being done, even if you end up leaving a little bit of money on the table. Yeah,
there's things besides money for sure. Okay, let's talk about, so you mentioned one of the cases that you said wasn't a personal win, but was a bigger win for domestic violence. Talk a little more about the other case, or elaborate on that case as well.
Yeah, so that case is called Marriage of Reichenthal. And just so you know, I'm not divulging any attorney-client privilege. These are published decisions, and so the facts are all laid out in the decision, and I'll just kind of talk about the decision a little bit in California law. So I can't remember the year, but a few years ago, California passed a law that said there's something called the California Law Enforcement Telecommunications System, and that's CLETS for short. And what would happen is if you got domestic violence, family law domestic violence restraining order against you, your name would go into the CLETS database. And what that meant was that all law enforcement personnel would have your name, the restrained party's name, in their database, in their patrol car, and then other things would ensue. You'd lose your Second Amendment privileges, rights. You would not be able to get a hold of state license. There were a number of things that law enforcement would lose their gun. That means they would lose their badge too. Military personnel would end up leaving the military. Nurses would lose their licenses. You couldn't get a job as a state contractor. So there are a number of pretty draconian penalties for having a restraining order against you, a DV restraining order. So judges started doing a workaround, and the workaround was a mutual stay away order, or what would be called a no match restraining order, or no math, would molest, annoy, threaten, communicate with, or harass kind of restraining order, but it would be a non-CLETS order. And so there would be these orders in place, but they wouldn't be reported to the CLETS system. So a few years ago, California said, no, you can't do that anymore. You either issue a restraining order and refer it to CLETS, or don't issue a restraining order, one or the other. And so we had a case that I had the wife who I wasn't involved in the DV hearing, but there were a number of things that she had done, none of which involved physical violence, but that she'd had a book sent to a book called Women, this is in the opinion. So she had a book called, she was a therapist, she had a book called Women Who Love Psychopaths, sent to herself from Amazon at her husband's house. He opened it, And this was one of the elements of domestic violence. There was another one where a friend was sitting on a hill. They had these big Santa Barbara mansions, and they bought the one next door for her. So she was sitting on the hill looking down into his yard and watching him wash his cars. So there were a few things that didn't look to me like this rose to the level of a domestic violence restraining order. So we took an appeal from what had been, so it'd been issued as a non-Kletz order. So we took an appeal from that saying, you can't issue a non-Kletz order, therefore the order should be vacated. And at the appellate court, one of the justices asked, I thought we were going to win this, by the way, because we had a panel of 3 justices and 2 of them seemed to be on our side on a different issue, not on that issue. And one of the justices said, well, why don't we just remand and have them tell them to issue a Kletz order? And I said, well, no, you can't do that because the judge already said it doesn't rise to the level of a Kletz order. So they disagreed. So they sent it back to the trial court. This is why we lost personally, and asked them to issue a Kletz restraining order. But so it was kind of a downer. I got fired off the case, obviously, and she was pretty mad. And anyway, but what it did was it expanded the bounds of coercive control, and that was sort of the unexpected benefit of this, was that what I thought, and so they agree. There's no non-Kletz orders, that it has to be a Kletz order or nothing. That was great, because I had a client get killed a few years ago because the judge just wouldn't give her a Kletz order because the husband hadn't been violent. He'd been controlling as all hell, but he hadn't been violent with her. And then we had this big blow up in court, and then he, rather than give her the money he was supposed to give her, he shot her, and he took the kid, and there was an Amber Alert, and he got killed eventually too by LAPD. And it was it was like a life scarring event for me. She was beloved in my office, very close with my paralegal, who's, you know, my right-hand person, has been for many years. We were devastated by that. And it was because they wouldn't issue a Kletz order. So this was near and dear to my heart, even though I thought in this case we were going to change the law for the better, but I also thought we were going to vacate this non-Kletz order. But what the unexpected benefit of it was the court saying behaviors like the ones that were found by the trial court to rise to domestic violence, which again, I didn't think did, and I still don't think they did, but was a much lower burden. And I think this is really important when I think of these 2 cases, my case where my client got murdered and my case where the appellate court, you know, didn't give us what we wanted. Because what we see now is behaviors like sending a book to your, would be an annoying book to get, right? Anybody would be annoyed by opening a book addressed to their spouse that said, well, women who love psychopaths. But that kind of behavior would never have been, I think it was very hard to find an older judge in California, I don't know about other states, who would have thought that that was domestic violence. They might have said, yeah, it's annoying, yeah, it could be harassing, but I'm not gonna, just don't do it again, you know, and let's move on. So to see this kind of behavior elevated to the level of domestic violence really is a lot about this coercive control, this new legislation in California. I think you said there's 2 other states that have it as well. We're starting to see this recognition that violence is, in fact, violence may be less bad than some of the mental torture and anguish that people go through when they're being very controlled by their spouse. And so in the end, even though we lost, I was really proud of of how we changed the law, and especially that non-Kletz order issue. And I think this expands the bounds of what people can ask for, you know, restraining orders on behalf of.
Yeah. I mean, it's bad that you lost, but it's great that it definitely brought more attention, and it makes the law bigger for coercive control.
Right. We're really expanding the bounds, and I really think that's good. And we're seeing it getting tested already. We had 2 cases in San Luis that became the central tenet, and the judge is a very young and really brilliant judge, and she was really thinking about it and saying, you know, this has become a gray area, a much more gray area than we had thought, disturbing a person's peace, you know, and really there was no question, there was no violence, and no physical violence in those cases. None was ever alleged, but it was really a question of whether or not the behavior arose to the level of being coercive control or molesting, annoying, not threatening but harassing. Was that what had it arisen to that level or not? So I like where we're seeing this go. We'll see if there's, we have a new Santa Barbara County and San Luis Obispo County, which is where my city straddles. Well, my city's in Santa Barbara County, but we're on the line for San Luis Obispo, so we can go both directions. We're seeing a turnover of more senior judges. There's a new generation of younger judges being appointed. They tend to be pro 50-50. They tend to be pretty hip to the idea that there's new ways of thinking psychologically about violence. There's, they're aware, they're very aware. And I think that is we'll see how it plays out as we teach them, we lawyers teach them, and as they teach us, their positions, there's going to be a back and forth for a while as we settle into what judges are going to do, what kind of things.
Yeah, interesting. I remember seeing that turnaround in teaching years ago when it was like all these old teachers suddenly retired and then all these new teachers came in. And when I was teaching, I was right on that wave. Yeah,
it's almost a sea change in education when that, or, we're going to see that too. I think a big change in how things are done. And I think that's really exciting. My entire one of the same judges, at least locally. And so now we're going to see, we're getting a new one soon. I mean, I've started practicing all over the state, but my home base is still here. And so these judges have been the same all along. And that's been great. It's great to develop a relationship. There's this old joke that says a good lawyer knows the law and a great lawyer knows the judge. And now I always thought that was meant to, the way they meant it was, smoke cigars with the judge or plays golf with the judge or whatever. But I think there's truth to the saying though. The truth is that knowing your judge, the psychology of the judge, how they rule on things, how they think about things can really help us position a client, in front of that judge. And I do think that you really do yourself a service when you hire somebody local, because local lawyers know that. They're in front of those judges every day. They have an idea of how they rule. They have an idea what to ask for. And sometimes having an outsider can cause they won't know how to present to that judge. And of course, the flip side of that is when everybody's too chummy and you really have an issue that's really important to you and the lawyer says, I'm not going to do it because the judge isn't going to like it. Sometimes, you're the client. So you should, if that's so important, you should have a chance to say it, go say it. I don't know you're going to get any traction, but I'll let you answer it. Let's figure out the questions and you get to answer them. And here's what I think could happen, but you're driving the bus, right? So you tell me if you want to answer it, knowing the risk, but I think, sometimes it can be too chummy if everybody knows each other too well. And I think people would say that about Santa Maria, by the way. I think there are a lot of lawyers who won't come here because they feel like this bar is too chummy with each other and with the judges. And that I'm not going to say whether I think that's true or not, but I do know that that's a complaint.
Yeah, actually, I was going to ask you a different question, but I'm thinking of a question that I got today from someone that we talked a couple of days ago, and I'll just throw it in here. She said, what do you do if you feel like there's corruption in your case? I don't know if you have an answer to that.
It's hard to know. Here's what I would say as a general proposition. I've known a lot of lawyers. I mean, I knew people in law school. I was a professor at LSU for a while. I was in the business college, but I had law students as students. I've 17 years, I've come across, I don't know how to put a number on it, but a lot of lawyers, and had a lot of chances to get to know them. It's so incredibly rare to find somebody who's corrupt. I don't think lawyers think they're being corrupt. I think that they advocate. I think sometimes they have lost the forest for the trees, and that they get so worked up into their advocacy positions that it becomes very personal, becomes very angry. I think that personal and angry lawyers are not very good lawyers. I think that they start to lose the big picture. So with that said, I don't know. When I hear the word corruption, especially as our cases get harder, and we get higher conflict cases now, we get higher value cases, we get cases where people are really upset, and And so the word corruption comes up at times. I have never met a judge or a lawyer that I thought was truly corrupt. And I think that we go down a path, and it's hard to get back out of that path. I think judges will make a decision, and then they've decided about who somebody is, and then to try to undo it is hard. You have to really, I mean, I work with people to it's almost like a damage control as the lawyer. How are we going to mitigate the view that the judge has, these determinations that have been made, perhaps by bad lawyering in the past, perhaps by a judge who made a snap decision, perhaps by a bad decision that a party has made. I mean, people make bad decisions. They're not bad people. They just make a bad decision. As judges decided that they're, not a good parent. And how do we minimize that? How can we go back and try to rebuild and say, all right, judge, I blew it before, but I won't do it again, and here's proof, or, those are the, so my thinking is and I don't want to speak for anybody else. I'm only speaking from my own experience. I don't think I've experienced corruption, but I have certainly experienced snap decision making that has become the underlying theme of the case. The judge has made a snap decision. You've got to get him or her off that position, and that's where I think it can be. We can work really hard on that, and not get anywhere. Sometimes we can work really hard on that and rehabilitate the person to the judge, but it's hard when it's affected your parenting time. And then the judge has decided that you're the alienating parent, so now you're getting 10% visitation with a supervisor or something. You can't give up, right? You have to keep trying to rehabilitate yourself, because you're never going to get your kids back if you give up. So it's almost like, but it's really challenging, because now you're burning up thousands of dollars trying to rehab yourself. It's probably the best thousands of dollars that you could spend in your case, but you might not be successful, and that's hard, And so my take on that is, if you're perceiving corruption, which there might be, I'm not saying that there isn't, I just saying that I haven't seen it, that you really have to work on rehabbing your image with the court. What do they think you've done bad, and how can you show that isn't actually factual? And sometimes it means being contrite for something that you don't think you did. I'm really sorry that happened. I'll do whatever it takes to prove to you that's not who I am. I show up every time. I do my drug test, or I go to AA. Like, here's my card. Like, whatever the judge thinks that made you into that place, you're really trying to rehab, that thing.
Yeah, I'm so glad you said that, because we often say to our clients that they don't really lose, they just give up too soon. And I think it has to do with what you're saying, that sometimes there's bad decisions, or it feels like corruption, or the judge has an impression of the person. They say there's no way to fix it, and they get tired, and they feel like that things will never change. Unfortunately, we've dealt with clients that are suicidal because they feel like they had a horrible decision and it's so unfair and nothing will change. But we've also talked to people who have come out of that, and it has changed, but it's been expensive and a lot of work.
It really is. And learning to, I don't know, do you have Our Family Wizard in use? I don't know if it's statewide or just in California, but learning to write on that program. I counsel, I counsel a number of things. One of those is, I get just as mad as everybody else when I get a nasty letter. I happen to get along really fabulously with my ex, and I think we co-parent great, even though we don't agree on everything. So we don't use Our Family Wizard, and we don't need to. But for the people who do, if you're already using it, you're already in a conflict place, right? Because the judge orders it because you're already there. And I think a lot of times people don't hear what they're writing. They don't hear the tone of their own voice, because they're just reading it. So I always counsel two things. One is wait before responding. What I do when I get mad, when I get a lawyer letter that I don't like, is, or even a client letter that I don't like, I try to wait. I used to have a 24-hour rule. Now I can cool off more quickly than that. But I will write something out of anger, then I'll spend a little time and go back and read it when I'm calmed down. And I think Our Family Wizard can just turn into a text war. That's not what it was built for, but it can just be a back and forth, kind of thing. And so I think people should wait. That's my first point, is wait. And my second point is write as little as possible. Say as few words as you can. That answer the question, and that's all. and that's all you have to do. And then post as much information as you can. So you're not the one who, your spouse can figure out your kid's school schedule, but if you have it, take a picture, post it, and just so you're saying, look, I provided all the information, I've answered all your questions, and I'm not engaging in a text fight with you. Just, this is what it is. And then once you've answered all the questions, I think you can shut it down and you don't have to respond again. If that means muting it on your phone or deleting the app for the afternoon so you don't get messages and reinstalling it later tonight, whatever it takes. But, you don't want to be in the same position as having two lawyers just, sniping at each other. You're not getting anywhere, and all you're doing is making yourself mad. And then eventually those things are evidence, right? And now, now it's who looked like a bigger jerk. And so the way you don't look like a jerk is you write as little as possible, and you make sure you're calm when you write it.
Yep. We spend a huge percentage of our time doing what's called strategic communication with our clients over our Family Wizard, email, any app, but exactly that with more detail. So I used to be a high school English teacher. And so some of our clients, we say, we're going to put you on the permission slip plan, which means you can get it out in an email, but it does not go to that person. It goes to us, and you have to get a permission slip before you send it. And that involves also waiting and having us check it and tweak it. Like, we won't write the thing for the person. Oh, have like free quick check-ins. We won't write it, but we'll check it and be like, no. Usually we're like, no. Sometimes we say, wow, that's amazing. But generally, no, fix this, and here's why. And they usually get it. And it's so helpful because it not only helps them learn to detach, but we find it turns the power dynamic around in these relationships, because a toxic person wants your attention. They want you to engage. So they're doing stuff to just pick, and then all of us often just go for the bait. And so Chris and I try to help step in and say, let's get a third neutral party in to stop right here, because it does become evidence, and you don't want to look like the crazy one, just like you said.
And I think that is brilliant. I'm so glad you guys are doing that. I'm guessing also that you're teaching them as they go, so that the notes they send you to look over are getting better and better, because they're realizing, oh, this is the style.
We don't even look over the notes. We say because again, the teaching thing, I'm like, we have to get on a call together, and we go through it together, and we go through templates with them and why and how tone sounds, and making themselves appear like they're trying to co-parent. Best co-parent. So we do a lot of work with writing.
That is really great. And you said something else, and I think that I always say that there's a tremendous power in the power dynamic in making somebody wait. There's tremendous power. They want you. The toxic person wants your attention now, and they'll know when they get it. It's like fishing. I haven't fished in so many years, but I can remember the one or two fish I've ever caught. It's like it hits the line, and it hits the line, and then you're like, oh my gosh, there's one out there, and then it takes it, right? And they know when you've taken it, right? They're trying to get you, and so they know when it's happened, because they get that text back with 7 exclamation points, or they get the one with all caps or whatever, and they know they got you, and now you're locked in, and you can't stop yourself. And so the power of waiting them. First of all, they start getting more impatient. They send another one and another one and another one. But not with being so passive aggressive that you just never respond, because then, that can drive somebody insane too. But certainly slowing the tempo down is so powerful.
Yeah. And my partner just wrote a comment to remind me to say, and part of what we do is we're always writing as if the judge is going to read it. So, and that's what I did with my own case. It's like this is the foundation, but everything I do, it's knowing that's going to be an exhibit, or it could be. So I have to always be careful. We call it being under the court's microscope.
Yes. Or I think of it as the judge is always CC'd on every one of your notes. So it's one that you read, for her to read.
Yep, definitely. Okay, so I want to talk about another thing that you said you started doing over the pandemic, which we loved, and that's that you lowered your retainer costs.
Yeah, so I started out, let me say a word about how I started out. I started out as a newly separated parent of an 18-month-old in a town that didn't have a university, and I wanted to be a university professor. And so I had a law degree, and I actually had a job offer in Louisiana, but my ex wasn't going to leave Santa Maria. She's a school teacher, and so I commuted for a couple of years, but it's a long story. But so when I first started out, I'd been at a big firm in San Francisco practicing, environmental, corporate environmental defense, toxic torts kind of work, and I knew that wasn't for me. So I didn't, but the main thing is I'd never been in a courtroom, and I'd been a lawyer for 3 or 4 years. I didn't know anything about family law. If you asked my class of, 700 people at Bolt Hall in Berkeley, who was going to be a solo practicing family lawyer, like 0 hands would have been raised, and I would have been sitting on my hands, right? I didn't have any interest in doing this, but I needed to find a way to make a living to be here in a town where I didn't know anybody, and I had an 18-month-old. So I started taking cash only, and I was pretty fluent, and I'm not anymore, but I was pretty fluent in Spanish then, cash only Spanish speaking divorces, in part because I didn't think I would get sued if I didn't do a good job, and I didn't know how to, but what I learned was I learned how to fight on my feet, and so that was a street fighting kind of business. We were one-off custody battles, one-off child support issues, and so, but as time went by, my reputation grew, and now I've been here a long time, and my retainers were going up, and I was wanting bigger cases, and I was getting bigger cases, and my billing rate was going up, and the barrier to entry was getting to be $10,000 to $12,000 just to get in the door, and we were getting it. But then, as the as the pandemic hit, people were hurting, and so what we did is we started to lower our retainers, in part to make the barrier to entry lower. I would still tell people, look, your case is going to cost more than $3,000, but you're in the door. You get some help from us, and then we make an agreement that you pay as you go. And if you don't pay, then we have an agreement. You're not a bad person because you can't afford a lawyer, like it's more expensive, and or you don't feel like you're getting what you need or whatever. Then we'll part ways amicably, and it saves me from doing all the state bar looks over everything on our trust account all the time, and so it saves me from being an accountant, which I don't like being. It lowers the barrier for the client to come in. And it also, the other thing is, psychologically speaking, when a client writes you a big check, you want to spend that money. It's not your money yet until you spend it. So that's why you might write a $10,000 check and get a $10,000 bill in your first month, because the lawyer wants to build the whole thing so you don't, take the money and run and you say, okay, I want to get paid back, let me get out of the case. So this also reduces our psychological, I don't think Helen and I have this psychology, but it reduces our psychological desire to spend every penny you just gave us so we can ask for more money. And so I think it's better for the client, so you don't get a bunch of extraneous work. And it's better for us because I don't have to do any accounting. And as long as there's a clear expectation with the client that we're gonna bill you each month, and then you always have a right to question an item on the bill. But once that's happened, then you have to pay it, or we agree that we're going to make some other arrangements. Sometimes we have people on payment plans. Some people want to do a lien on their house. I hate doing liens on houses, but sometimes people do that. Sometimes someone says, I got to cash in a 401k, but I can't do that till later. Are you willing to work with extend credit, which we might do under certain circumstances? So we're trying to reduce the barrier because, especially in this town, there aren't enough lawyers, and there isn't enough money for people to pay for $10,000 retainers over and over. But so it's a service to the court too, because the judges need us. I mean, otherwise they're dealing with 90% of their cases are snarled up pro per cases that are just all twisted up. And, they come to me and they say, can you fix this? And I'm like, God, yes, but geez, and so then it costs more to unsnarl it than it would have been to just do it the right way the first time. So we're trying to help people by doing it the right way the first time for them, saying, look, if you only have $5,000 to spend, we can work with you on that. Let's have this be our target drop-off point. We're going to work till we get to that point. That'll be about $5,000. At that point, you can take it from there, but this is what you'll have in hand. You'll have a custody order, you'll have a support order, and you'll have your financial disclosures done. And then you can work on the financial disclosures with your ex, and I'll tell you, this is what you're going to divide all these by 2. These are all 50-50. So just go do that part, and then you write up an agreement yourself, or come back and ask us to write the agreement for you. We'll do that. We'll do that, for another 2 or 3 hours worth of time. And I think
I mean, what you're describing is what we always we always push for our community is limited scope services.
Yeah.
Though it's not, yeah, it's almost like contract work on unbundled services, but you're talking about capping it, where it's like someone says, look, this is how much money I have. What can you do? And it sounds like there has to be good communication, because the expectation is made clear from the beginning. This is what we can do. This is what I mean, you never know exactly, but you can have a better sense of it. And people can't afford like the $15,000 retainer.
Nope.
A lot of our people go pro se. I mean, I'm pro se after a $100,000 divorce, and now I'm in my 8th year
Oh my God.
post judgment, 5 years post judgment. But we can't, most people don't have that kind of money to just burn through. So I think what you're describing is also empowering.
And part of the flip side of that is that unbundled services, just purely unbundled services, are very transactional. And I'm an emotional being. I want to attach to my clients. I want to be their champion and rally to their cause. If you come to me and say, can you prepare a petition for me? But I'll have one of my paralegals, who are both fabulous, do it. And we're training another one, and she's great too. Well, they'll do it, but I don't have any investment in the case. I don't know the person. I will have consulted with them for an hour. They will then have paid for a petition to be drafted and filed, and perhaps come back and get their disclosures. That's fine, but I don't know how to give advice in that context, because I want to know a person a little bit. I will do an hour call with somebody and let them just vent and go through everything that's gone on, because I want to know that. I need to know how they talk. I know how they are when they're under pressure. I need to know their view of their entire case, what their aspirations are in the case. Some dads say, I want 50-50. That's great, but do you know what 50-50 looks like? And then I say, well, no, I didn't realize all that. I'm going to drop them at her house in the morning. She's going to take them to school. Who's going to take care of them when they're sick? Well, she will. And I'm like, that's not 50-50. What you want is to tell your friends you have 50-50, but what you want is something else. Let's go for that. Let's make your expectations work. But I need to know the person a little bit for that, and you can't get that with unbundled services very easily. So my idea is hire us with, scrape together the most you can get. Let's work with what we have, and I'll tell you, this is about what that is going to buy you in this case. Now, I can't promise, because if your ex goes and hires one of those lawyers that I can't work with, we're going to blow through that, and you should take that money and go somewhere else. And they will, yeah, but I already really like you. Yeah, but I don't like that lawyer, and I'm trying to make your money last as long as I can. And so I think, I have tried and failed multiple times to start something called the Family Law Clinic, that would be unbundled services with the oversight of an attorney. Because one of my problems, I love that there are people out there who prepare documents, but they cross the line into practicing law too much, and they're malpracticing all the time. But there's no risk to them because they don't have a license. And so my idea with the clinic would be that you would come in and make an appointment. You'd get 15 or 20 minutes of the lawyer's time. You'd have a paralegal prepare documents, and you go file them. And then you could come in and then anytime you wanted, you could buy an hour of a lawyer's time and say, okay, here's what's going on. I could just never get it to take off. I still think it's a perfect idea. And
It is. It should be in every courthouse. We have little things like that.
It never gets phone to ring, but I really think, it's just, it's what we should be doing. And because this is not that hard. The divorce part is not that hard. I mean, custody is more difficult because the judge has so much power, but the money is not hard. The money should be easy. And it shouldn't cost. You could divide, these clients are divided $7 million and they spent $3,000, right? And they were mad about spending $3,000. They said it's just divided by 2, and I said, I still have to prepare an agreement for you, and you have to file the paperwork and do your disclosures. But the point is, it's not hard to divide money. It's easy to divide it, but you need to push. And that's what the book was supposed to be about, or is about, is here's how to do it. You have to invest $35 in 400 pages of reading, but it's going to teach you how to think about it, not how to do it necessarily, but here's how you should put your mindset as you do this. And so I really thought, the Family Law Clinic was a great way to go, but maybe we'll try it again. If Helen's listening, she can tell me later whether she wants to try it again. But I just think it'd be such a great thing.
It's a necessary thing. Really necessary. I know it'd make a lot of people thrilled. Okay, so also this morning's quote, I don't know if you saw it, but I actually took it from you. You had said something about you are truly your own best advocate.
Yeah.
And it makes me think about what we're talking about here.
Yeah, there's, nobody knows your case like you do. You know it the best, and because you're living it. Now, whether you're objective about it or not is a different question. I think people can hire people like you guys that could help them be objective about it. They can talk to people like me who can try to help them. I think they should do that to get a little bit of objectivity. But nobody's going to advocate like you do for yourself. I think, now I feel like I'm like promoting my book, which isn't a book. I mean, right now it's a manuscript, but there's a whole chapter on courtroom decorum. I think that people sometimes don't realize that they're advocating for themselves, but they're over advocating. They're going too far, and they've lost their judge, and they're getting frustrated. And so all of that said, you know the thing that you want the most in a divorce. And like I try to, in a settlement conference, I try to figure out ahead of time. Well, first of all, I always tell my client in a settlement conference, we're on a listening tour. All right, this is about us listening to them, and they're going to tell us everything if we let them, because one thing I know about awkward silence is that somebody's going to fill it. So if we are awkwardly silent, they will tell us everything they want, and once we know what they want, we can figure out how we're going to give it to them and get you the thing that you want. I already know what my client wants, right? So my idea is you know your story, you know the thing that you want, you know what you're looking for, you can advocate for yourself. You just have to learn the right way to do it. And if you're going to be pro se, then my advice always is to go watch your judge on a day that isn't your day, and see who. All you're doing is watching the judge and watching the lawyers and watching the parties, and you see who's pissing the judge off, and you see who's not getting orders, and you see that stuff. That way you're more able to present your case in a way that truly advocates for yourself, but also in a way that the judge can hear it. Because every judge is different, too, and they like different things.
Oh, definitely. Yeah. And I'm thrilled hearing what you say, because this is the same stuff we tell our clients. You know your case better. We also say, you know your ex better than anyone else.
Yeah, absolutely. I always start with, what does your ex want? Do they want the house? Mm-hmm. Are they willing to break you over the kids because they know you want the kids? Like what is it that they're going to be after in this case? Well, I have another point in the book that says, if your lawyer's filing a motion that you don't understand, don't let them file it. You should know. You should have. Not only should you know, do you know your case better, but you should know it better. So if you're not understanding they're talking about, complex family law reimbursements, I want to know. I want to know, what are my chances of winning? How much is it going to cost me? And what do we get if we win? Then you can do an analysis. If we have a 50% chance of getting $25,000, cost me $10,000 to take that chance, I'm not doing it, because I could lose. I could spend $10,000 and lose, and I still have to pay $25,000, and all I was getting, and if I won, was $2,500 out of this, because I had to pay you 10. You shouldn't let your lawyer file. They wanted that. These are just ways of, I'm not saying that they're doing a bad job. It's proper. They're doing the right job, but but you should be in control of that. You should be able to say, no, I don't want to do that because I don't understand it. You're
speaking our language. We call this taking strategic oversight of your case.
Yes.
And we tell so many of our clients or people that just get on discovery calls with us, this is so important. And that, especially for so many of our people, they're coming out of these relationships where there's been coercive control, there's been all kinds of financial abuse, whatever. And we're saying, if you come out of this in this vulnerable state and you basically throw $15,000 at a lawyer and say, save my life, you're repeating the cycle of a toxic relationship.
Yeah, that's a great thought of that.
You have to pull. We have all kinds of terms that we just come up. We say, often people show up to us and they're like a puddle. So our job is to put you back together so that you can start holding the reins again and running your life like a business, and realizing like you need to hire maybe a lawyer. They're going to do the law stuff. You've got family and friends, maybe, if you haven't been isolated, they're going to love you, but they don't totally get it. So they'll say things that might hurt you inadvertently, like, oh, why doesn't the judge do this? Or why don't you just do this? Or why isn't it, and drive you crazy? Then you've got like a domestic violence advocate, which I am, or a therapist, or both. And that person's going to work on your healing, but they often don't understand the reality of family court. So then we'd be saying, oh, just don't answer that person, but that'll bite you in the butt if you're dealing with a custody battle, because then you look horrible and they could build a parental alienation case against you. Chris and I have this image of a table, so all different legs. So then the fourth leg is someone like us, who we give you the New York reality check of what family court expects. We talk about a lot of things that you mentioned, the decorum of the court, which we call ethos, the pathos, which is your presentation and how you're perceived, and then the logos, which is like the facts and the evidence of the case, and everything has to go together, and you have to present really well, and whether you're a witness or pro se or pro per, but you need that credibility. You want the judge to pay attention. You're not going to have a lot of time to do it, and here's what to expect generally. And so I love everything that you're saying, because you're on the same page as we are.
Great. I love that what you're talking about. That's excellent.
Well, that's why one of ours recommended you, and I'm like, this is awesome. And I think I'm not sure if she's on here. I saw her pop in before. I'm not going to say her name, but we both know who it is.
Yes.
Yeah. But so Jude, thank you so much for taking all this time to talk to me about this. How can people find you?
My website is Jude Egan Law, JudeEganLaw.com.
Okay, great.
And you can is that the well? And then I'm on Instagram, although I don't use Instagram professionally per se, but I think there's a I'm not doing much with social media, I guess.
Yeah. Well, I'm tagging you because I have this recording is going to be posted, and I posted a little announcement, and I'll do another one later. But it's at Jude Should Be Writing.
Jude Should Be Writing. That's right.
Yeah. Yeah. But they'll find you.
Yeah, and people can. My email address is just jude@judeeganlaw.com. People are welcome to send me emails. I don't, I have to be careful about legal advice, but I'm happy to give my thoughts on things if people have questions that they want to ask me, personally. Or they can. A lot of people have been following me before as you made the announcement, and they're welcome to send me. Somebody, criminal defense lawyer friend of mine told me that messenger app is not considered secure communication. So I would send an email rather than, but you could send me an email and ask for my email, or send me a message and ask for my email address. And I'm happy to send it to you and we can chat about things, offline. But I probably don't think you should send me a detailed question on Messenger, just because this guy's really smart. And if he's really smart, then I want to do what he says. And so he says, so he's a criminal defense lawyer, like I said, but maybe because there's be subpoenaed. I don't know. Just don't do it.
Yeah.
But I'm happy to happy to chat with people via email.
All right, excellent. Well, thanks again, and we definitely, if you want to, have you back to keep talking about stuff like this.
Be great. Anytime.
Okay, good. All right, thank you so much.
Thank you. All right.
Talk to you later. Bye.